Well, good morning. I'm Jagendra Rana. Topic for our discussion today is third party liability in motor insurance. Third party liability in motor insurance. So India has a distinction of having one of the most accident vehicle ratios in the world. This realization lead the country towards mandatory insurance for all the vehicles flying on the Indian roads, which provide coverage to general public against the risk of injury, death, besides property damage. As the motor insurance concept came into existence, and Motor Vehicle Act made the insurance compulsory for everyone driving the vehicle on public place. It got widespread publicity and became popular amongst the masses. Section 146 of Motor Vehicle Act 1988 seeks to protect members of public traveling in vehicles or using the roads or public place from the financial liability caused by the risk attended upon the use of motor vehicles on the roads by making third-party insurance compulsory for users of motor vehicles. The motor accidents are as major contributor of loss of human lives and property besides natural calamities and disasters in most parts of the world, and India is no exception to it, as crores of vehicles are plying on Indian roads. So to compensate these losses, motor insurance is only the logical conclusion. A third-party insurance policy covers only the inter alia liability of the vehicle owner for loss or damage to life or property of the third parties, whereas comprehensive insurance policy covers, in addition to third party liability, loss or damage to the vehicle itself by way of accident, theft, and specialized perils. The policy covers the vehicle owner's legal liability to pay compensation for death or bodily injury to a third party or third person, and damage to third party property. So the liability is covered for an unlimited amount in respect of death or injury, and damage to third party property is restricted to rupees 6,000 only. However, an enhanced cover is in force for rupees 7.5 lakh under commercial vehicles and private cars, rupees 1 lakh for two-wheelers. So, third party liability means insurance is a contract between two parties, that is insured and the insurance company. Therefore, the two parties of the contract are the first party and the second party respectively. It effectively means that anybody outside the contract is a third party. This also includes the property belonging to any party outside the contracting parties. Any liability occurring towards this third party due to the use of the motor vehicle is third party liability. That may be in the form of bodily injury and or death or third party or damage to third party property. Now, any motor accident gives rise to two kinds of liabilities. One is criminal liability and another is civil liability. So the state takes action in the former and the latter is dealt with under law of tort. The provisions relating to compulsory third-party insurance do not apply to any vehicle owned by the central government or state government and used for government purposes and unconnected with any commercial enterprise. However, the above exemption is made only if a fund is established and maintained by that authority for meeting any liability arising out of the use of any vehicle. So the fund has to be established in accordance with the rules framed under the Act. Now, studies reveal that it is the pedestrians or cyclists who are the victim most of the time on the road. The tragedy is most of these victims belong to the poor section of the society and are unaware of their rights of compensation from the owner drivers for the rash and negligent driving. So the rash and negligent driving resulting into injury, death creates two liabilities for the wrongdoers, that is criminal liability and civil liability. So for criminal liability, it is the state that initiates the proceedings, and as regards the civil liability, it is the victim himself who has to file a claim for compensation. So a claim for compensation for death, injury or property damage resulting out of the use of the motor vehicle can be filed by the affected persons as under, like persons injured or all or any legal representatives of the deceased or duty authorized agent of the category, duly authorized agent of these two categories. Now the claim can be filed in MSET or the Workmen Compensation Court with jurisdiction on the place of accident, residence or business of claimant or the residence of dependent. There is no time limit to file the compensation claim by claimants. Although the law of compensation for accident victims under the Motor Vehicle Act has not been static and has grown towards improvement of by travelling. In the year 1956, Section 110A to 110F were introduced in the Motor Vehicle Act 1938-39. So prior to this amendment, the claimant has to sue the insured person in the civil courts. So further amendments were made in the year 1969, making provisions for property damage. The Section 165 of the Motor Vehicle Act 1988 authorizes the state government to constitute the motor accident claim tribunal. So the tribunal so constituted is not a civil court. However, in certain matters, it has the same powers as those enjoyed by the civil courts. Further, Section 175 of the Motor Vehicle Act 1988 puts a bar on the civil courts to entertain the road accident cases. So the victims or the dependents or the representatives cannot approach civil courts for remedy. They have to approach only the motor accident claim tribunals for putting up their cases. These tribunals were set up for speedy and cost-effective trials for victims of the road accidents. Now there is third-party property damage claims. So under the third-party liability cover, there is an option to restrict the third-party property damage cover to the statutory limit of ₹6,000 as provided in the Motor Vehicle Act. However, this cover can be increased to ₹1 lakh for two-wheelers and ₹7.5 lakh for cars and other commercial vehicles by paying a nominal additional premium of 300 and 150, and for taxis 50 only. Premium varies from time to time. So this option, however, is not applicable to damages caused to humans. The property damage limit, however, is subject to a minimum of ₹6,000 being the statutory limit that could be increased upon payment of the additional premium. So the insurer would refer to this policy for the additional amount of coverage, if any, over and above the statutory limit, and would take appropriate measures thereafter. Then there is the out-of-court settlement. Normally, the liability of owner is insured as he has been named in the policy. However, on the principle of vicarious liability, drivers and hires liability are also insured, provided they act as if insured and complies with the terms and conditions of the policy and are driving the vehicle with the permission of the insured. If they act outside the scope of the employment, the liability rests with them. The insurer in such cases may deny the liability or seek reimbursement from the owner if they were made to pay. Therefore, third parties falling within its meaning are covered and are to be compensated for the damages they suffer on account of negligent use of the vehicle. So the use of the vehicle is another important factor having a strong bearing on the claim for compensation. The use of vehicle and the accident thereof does not necessarily mean that the vehicle may be running on road. A vehicle stranded on the road after a breakdown or a stationary vehicle can also be held liable for the damages. In Savaji Diana versus Vatsalatam More case, a petrol tanker overturned over a collision with a truck after 4 hours and a half The tanker exploded, resulting injuries and death to several persons. It was held that the death was due to the vehicle accident. So the next factor remains to be understood is the limit of liability. There is no discrepancy as far as limit of liability towards injury or death is concerned. That is, it is unlimited irrespective of the class of vehicles, or the compensation is not subject to any limitation. The only consideration being the negligence or fault is to be proved. So the claimant would, however, have to justify the amount of relief they claim based upon various parameters. The Law Commission has observed that even the negligence is irrelevant. It is not essential to allege and prove the negligence for making the insurance company liable for payment of compensation, and that the liability of insurance company was absolute, though limited to the extent provided in the policy. So the claim can be filed under any of the following sections of the Motor Vehicle Act. Section 140, 166, applicable where there is a death or permanent disablement has taken place. Section 166, applicable where there is neither death nor permanent disablement. It is for the injury which may be simple or grievous but not resulting in permanent disablement. Section 163A, a compensation is on a structured formula basis on the negligence on the part of the driver or owner of the vehicle. It is not required to be established by the claimant. The Workman Compensation Code takes care of liability against the owner in case of accident to driver, cleaner, conductor, or other employees covered under the WC Act 1923. However, whenever the extra premium is charged for driver, cleaner of the employees engaged in vehicle, then under the wider liability provisions, the same category of employees can also file the case. No fault liability provision is also there for immediate compensation in case of death and permanent disability. Then there are hit and run cases. Hit and run motor accident means an accident arising out of the use of the motor vehicle, the identity whereof cannot be ascertained. At present, the motor accident claims are settled in the following forums of original jurisdiction, that is, Motor Accident Claims Tribunal, Lok Adalats, and Workmen Compensation Courts. Section 161 of the Motor Vehicle Act provides compensation for death and grievous injury in case of accidents where identity of the vehicle is not ascertained. As per this section, the amount is very limited. So a fund known as the Solution Fund has been created with equal sharing from the central or state government, and the Insurance Solution Fund means a token sum of compensation. Lok Adalats are also there for settlement. Lok Adalat settles dispute, reconciliation, and compromise. The first Lok Adalat was held in Chennai in 1986. Lok Adalat accepts the cases which could be settled by conciliation and compromise and pending in the regular courts within their jurisdiction. Main condition of the Lok Adalat is that both parties in dispute should agree for settlement. This decision of Lok Adalat is binding on the party to the dispute, and this order is capable of execution through legal process. So management of third-party pool, third-party claims is necessary because the liability of the insurer arises only when the liability of the insured has been upheld for the purpose of indemnifying the claimants. The area where the insurer should exercise some control to achieve the desired results and avoid the disastrous financial consequences. A motor third-party pool was established earlier, which is now abolished. It was not a successful experiment. Now the situation is that MSCT and Workmen Compensation Courts are deciding the compensation for the road victims because the number of cases are increasing every year. This situation may become hopeless, or imposition of marriage, motor accident are as major contributor of loss of human lives and property, besides natural calamities and disasters in most parts of the world. And India is no exception to it, as crores of vehicles are plying on Indian roads. Thank you very much.